Well, thank you very much for inviting me here. It's wonderful to be in Eugene, and thanks for the kind words, Mary and Rennard. It's an honor to give the lecture in your name. Dean Moffat, thanks for hosting this and coming. I really appreciate it. I also want to thank the wonderful assistance I got from Heather Brinton today and Emily Johnson, and thank your program and the students who I had lunch with today. It was very fun to sit with you and talk about the law. I also want to acknowledge my good friend and colleague Adele Amos. It's fantastic to be down here. I brought up this Oregon Law Review from 2001, which has the Rennard Strickland tribute section in it. I don't know if any law librarians are here, or reference librarians, but our librarians are wonderful, and I'm sure yours are too. And this showed up in my office one day and marked with the pages where the tributes to Rennard were. And so I looked at it, and I found one tribute that was written by Chad Smith, then the principal chief of the Cherokee Nation. And it was a very short piece, but it was very interesting. And he wrote about a 1970 piece that Rennard had published in the Journal of American Indian Education, discussing the linkage between two nascent movements that were in the news in 1970. I thought about Mary's new book in the event that you had the other night as I read this. And here's what Rennard wrote back in 1970. If ecology has become the crusade of the 70s, then the Indian has likewise become the minority of the decade. The year 1970 has been called the Year of the Indian. Almost every major magazine has recently carried a story on Indians. A Time cover story was called Tonto is Dead. And even Playboy featured 2 Indian articles, but no centerfold. It's Rennard's words, not mine. I was shocked when I read that. The Indian movement is said to be coming of age. Indians have their own protest folk singer, Buffy St. Marie, a Cree, and there is talk of red power among the new Indians. In the year 1969, ended with that wonderful, almost Gilbert and Sullivan seizure of Alcatraz. We have all heard the bromide. You cannot stop an idea whose time has come. I love that phrase, bromide. May I suggest the idea whose time has come? The idea is that man must save his environment in order to save himself. May I even be bolder and suggest that in this quest, our guiding vision must come not from the sophisticated scientists, but from the material impoverished, from the so-called primitive, from the American Indian. My contention is that the ideal of the Indian may make science worth saving. It is not an accident that the idea of ecology and the ideal of the Indian should emerge simultaneously as national issues. From the Indian, we can learn that we must live in partnership with nature. So you may be wondering, what does this have to do with my topic, the trust responsibility? Well, just as mankind generally is stuck living with nature if we want to exist and take care of ourselves and our future generations, Indian nations in the United States are stuck with the United States government. This grows out of international law and the colonization that took place in the beginning in the 15th century. And so Indian nations have always had this struggle to relate to the colonial powers, whether it was the European powers or now the United States. The colonizers wanted the land, and they got it through the series of treaties and agreements that were negotiated or coerced during the 19th century. Promises were made by the United States to secure tribal sovereignty permanently, to protect tribal natural resources, and again, involuntarily assumed was the obligation on the part of the United States to manage these resources that the United States had seized from the tribes and asserted through their power and dominance. We look back from 2013 at the year 1970, and I think Mary's work shows us that things have not gone real well with the environment. You go up to Alaska and you see villages having to relocate. It's getting worse all the time. It's a crisis. We look at Native American affairs, and I think generally things have improved a lot since 1970 in terms of the relationship between the United States and tribes. Is very rocky yet, but the work that activists did in the 1970s has led to significant improvements in the relationship between tribes and the United States, although there are many shortcomings. The Supreme Court has noted that the federal government and others had colonized the United States, but the law of nations mandated that Indian tribes were owed a duty of protection from others, from the states, and selfishly from the United States perspective, from dealing with other nations in order to maintain the monopoly on dealing with tribes and acquiring their lands. The promise of government-to-government relationship and political allegiances remain at the foundation of the federal trust responsibility, despite the vacillating federal policies that I'll touch on as I move forward. Again, I want to quote Rennard a little bit here from that's why I have these books out here, my props. So this is from the 1982 Cohen Handbook, which Rennard was a editor-in-chief, and your own expatriate Charles Wilkinson was a managing editor of the book. So in the history chapter, that has remained substantially the same because history doesn't change that much, and Rennard's a good historian, so why reinvent the wheel? Understanding history is crucial to understanding doctrinal developments in the field of Indian law. For example, treaty making with Indian tribes involved matters of immense scope. The transactions totaled more than 2 billion acres, and some individual treaties dealt with land concessions involving tens of millions of dollars, tens of millions of acres. At the same time, treaties included minutiae, such as the provision of scissors, sugar, needles, and hose. Yet out of their felt needs of the parties to the treaty negotiations, there evolved comprehensive principles that have continued significance to this day. These include the sanctity of Indian title to land, the necessary preeminence of federal power in action, that's the bad side, but it's there, the exclusion of state jurisdiction, the sovereign status of the tribes, and the special trust relationship between Indian tribes and the United States. These principles endure beyond the four corners of negotiated treaties. Congress ended treaty making in 1871, but the principles lived on in the treaty substitutes that followed in the form of agreements, executive orders, and statute. Thus, what is seemingly background becomes the foreground, indeed the basis for contemporary judgments. So that's up to 1870 we're talking about here, this brief skate down memory lane of the early history of the United States. The period that followed 1870 was really marked by 60 years of efforts to assimilate Indian people into mainstream society, to stamp out Indian religions through boarding school processes, to stamp out native languages, to remove Indian children from their culture through the boarding school process, and to break up the tribal communal land base, all in the name of getting rid of the Indian problem that Congress saw in the executive. There was a brief respite from this assault on tribal communities beginning in 1934 with the Indian Reorganization Act and the Roosevelt administration. After World War II, we quickly slipped back into a termination model in which Congress was selectively terminating the federal-tribal relationship, ending the trust relationship, a lot of it here in Oregon, in order to get out of the Indian business. By 1960, both candidates for the White House, President Kennedy and Richard Nixon, repudiated the termination policy, but it lingered through the 1960s and even into the 1970s. And it was, so it's not that long ago. If you look at that sweep of history, the United States existence, and you see a treaty-making era, then you see 60 years of assimilation, another 10 or 15 years of termination, and yet tribes persist to this day as strong governments and managers of their people and lands. When Rennard was writing his piece that was published in October of 1970, Richard Nixon, of all people, was giving his special message to Congress, rejecting the policy of termination. And here are his words. "The policy of forced termination is wrong, in my judgment, for a number of reasons. The premises on which it rests are wrong. Termination implies that the federal government has taken on a trusteeship for Indian communities as an act of generosity toward a disadvantaged people, and that can therefore discontinue this responsibility on a unilateral basis whenever it sees fit. But the unique status of Indian tribes does not rest on any premise such as this. The special relationship between Indians and the federal government is the result of solemn obligations which have been entered into by the United States government down through the years, through written treaties, through formal and informal agreements, and our government has made specific commitments to the Indian people. For their part, the Indians have often surrendered claims to vast tracts of land and have accepted life on government reservations. In exchange, the government has agreed to provide community services such as health, education, and public safety, services that would presumably allow Indian communities to enjoy a standard of living comparable to that of other Americans. Federal termination errs in one direction. Federal paternalism errs in the other. Only by clearly rejecting both of these extremes can we achieve a policy which truly serves the best interests of the Indian people. Self-determination among the Indian people can and must be encouraged without the threat of eventual termination. In my view, in fact, that is the only way that self-determination can effectively be fostered. And so this policy, announced in 1970, persists to this day. It is a strong policy of the United States. It's carried out in ways that reflect this tension between paternalism and sometimes creeping feelings of termination that the government wants to get out of its obligations and not continue to fulfill its duties to protect tribal assets, tribal sovereignty, and so on. And so it's a constant battle on the part of the tribes and their advocates to keep the government on its toes. The American Indian Policy Review Commission was created by Congress in the mid-1970s, 1975. They had a big staff. They had a budget of a couple of $1 million. They produced a report of, I think it takes up about 13 volumes on my shelf. They had a lot of recommendations about things that should be done to improve the relationship between tribes and the United States. Some of them found voice in legislation. There was a Self-Determination Act that was passed through Congress so that the Indian tribes could take over the functions that the government had carried out in a very paternalistic way in terms of providing services. Another act that passed in 1978 was the Tribally Controlled Colleges and Universities Act, which sort of sat dormant for a while, but now we're seeing flourishing tribal community colleges and four-year colleges throughout the United States. There were statutes related to forest resources, to Indian mineral development, all geared to getting tribes to have a better shot at managing their own resources with government assistance when necessary, but to make tribes the primary managers. The Clean Air Act and the Clean Water Act were amended to provide tribes with treatment as a state status so that they could regulate pursuant to federal delegations on their reservation of power. Now, these are all good. These are things that help promote tribal sovereignty, local control, and things of that nature. The biggest persistent problem has been federal asset management. The United States, as trustee, assumed that it had title, a legal title to Indian property. I've yet to see a treaty that said that, but that was the assumption that the United States worked under, that it would have to approve any leases, that it had the power and the authority to lease tribal oil and gas,
to third parties and take the funds in. Congress provided an interest rate and places for that money to be kept. And in the mid-'80s, oversight hearings were conducted in Congress, and it was revealed what a shambles the system was in. And this is not a new thing. The explorer and later government official Henry Schoolcraft, in 1828, he was up in my territory in northern Minnesota, lived with the tribes for over 30 years, a great writer. This is what he said in 1828, after spending some time in D.C. The derangements in the fiscal affairs of the Indian Department are in the extreme. One would think that appropriations had been handled with a pitchfork. There is a screw loose in the public machinery somewhere. Let's fast forward to 2008, and we see litigation, the Cobell litigation. Lawyers for a mile firm, NARF, go to the United States on behalf of Eloise Cobell and ask what anyone is entitled to who has money in a bank for an accounting. You know, show me what came in, what went out, to whom, what was the basis for the payment on a given lease. Well, no records. Couldn't find it. And after about, 14 years of litigation, I think about 12 or 13 trips to the D.C. Court of Appeals that produced published opinions in the Fed Third, this huge settlement was entered into for $3.4 billion. And this is only for individual Indian accounts. This is for 10 million acres out of the total of 56 million acres of Indian land in the United States. So it was followed by numerous lawsuits, some of which are pending. The Obama administration, to its credit, has settled many of the tribal lawsuits, but many continue to hang out there. And I just, you know, I've given them a little credit for settling these cases, but I don't want to go too far. There's an example, it's so egregious so that I just have to tell you. It's an Osage accounting case. And the Osage tribe went to the department and asked for an accounting. The department said, we're not required to give you an accounting under the statute that sets up your system of land ownership. Why not? Well, it doesn't direct us to carry out that function, and we only, as trustee, we only have to do what Congress directs us, not what any other common law trustee would have to do. Tribe sues, wins, the government enters into a settlement with them, and get this, they make the tribe sign a waiver that says that they will not assert any claims on behalf of Osage tribal members who are in exactly the same position as the tribe. And in order to get the settlement, the tribe had to do it. While the tribe couldn't bar individuals from bringing these cases, the United States had to know that, but they nevertheless pressured the tribe into this sort of a settlement clause. Well, tribes, you know, they did help the individuals get a lawyer. They get a lawyer. The lawyers sue the United States. The United States says, nope, you don't. There's nothing in the statute that requires us to give you an accounting. But you just settled with the tribe. Well, that was the tribe, and they waived your claims. So you can't bring an accounting. The case goes up to the 10th Circuit, and the judge wrote a scathing opinion tearing the United States up and down for this breach of fiduciary responsibilities, citing, I was glad to see, the common law of trusts, Bogert, these treatises that spell out the duties that are entailed to any trustee, and said once you have taken these assets under your control, you've got all these common law obligations. And this came out about a month and a half ago. And so it shows both the worst of the United States, including this administration. It's a career lawyers that are taking these positions, and nobody is watching. You know, they're positions that they've taken in litigation all along, and no one says, hey, why are we doing this? In light of these settlements and our trust responsibility. So it's extremely disappointing. So, anyhow, the good news is, as a result of this situation that I've described briefly here, Secretary Salazar, after the Cobell settlement was signed, appointed a commission to conduct, quote, a thorough evaluation of the existing management and administration of the trust administration system to support a reasoned and factually based set of options for potential management improvements. In addition, the Secretary encouraged the Commission at its first meeting to be creative and review any aspects of the trust relationship that it chose to. I was, I don't know if it was fortunate or not, but I was appointed to that commission, along with Pete Zaw, the former president of the Navajo Nation, Tex Hall up at Fort Berthold, and the chairman of the Great Plains Tribal Chairmen's Association, Fawn Hall, who's the tribal chairperson at Quinault, and the president of the Affiliated Tribes of Northwest Indians, and finally, my good friend and Rennard's good friend, Stacy Leeds, who's the dean at the University of Arkansas. So we traveled around the country and had we had about 8 hearings in different places, ranging from Alaska to the Northeast, Oklahoma, and so on. And, you know, we just sat in a room like this. We would talk for a while, and then we would have people would come and tell us what's going on. And, of course, the lawyers would write us long memoranda about particular problems that their clients had encountered, which were very useful to the commission. And there was praise for some individual Bureau of Indian Affairs employees, and lots of criticism of the fact that there's not enough money. There's never enough money to carry out these functions properly. So with this oil and gas boom in North Dakota, for example, there's only one hydro geologist to deal with the relationship between the groundwater and the places where they're fracking. You know, so they don't really know what's going on when they're doing all of this exploration on Indian reservations, and it's just a matter of funds. So it's a real disaster. So this commission traveled around, and we had almost no staff. We weren't like the American Indian Policy Review Commission that had a couple of $1 million budget, but they paid our expenses and took our time gratis. But we gave it, and now we're going to give them a report. And the report is going to recount a lot of the testimony about these problems that have occurred. And one thing the Secretary did do was come up with enough money to hire an accounting firm to look at these problems that led to the Cobell litigation, this inability to keep track of funds that are coming in and going out. And that accounting firm did a really good job. The name is Grant Thornton. They identified all sorts of defects in the systems that the United States employs to account for funds, to conduct appraisals of resources when there's going to be a lease, to make sure you're getting the right amount of money, communication. A lot of what the government does is also provide services to individuals who have these, they're called individual Indian money accounts, and there are hundreds of thousands of them, and it's as a result of the policies in the 19th century, the individuals have maybe very small shares of a piece of land on an Indian reservation or even off of a reservation. But funds come into those accounts, and it's difficult to navigate the system. And so, I mean, this accountant report, you know, identifies ways to provide services better. And so it's like, okay, here's a website that a real bank uses. Why don't you get one like this so people can access their account and see how much money is there and who the land is being leased to? Good idea. And so it's full of little things like that. But what they also did, we said, well, why don't you suggest a new structure? And so I think probably the most controversial recommendation that's going to come out of this report is, they recommend that the Bureau of Indian Affairs all trust asset functions, which is most of the Bureau, be transferred to an independent commission that would be within the Department of the Interior but independent from the Secretary. So it would be like FERC in the Department of Energy. And this commission would have direct authority to go to OMB to seek funding, so you would deal with the funding problem in that fashion. And current offices would be ones that are functioning, kept intact, but lines of communication are broken in many places, and so they would fix those sorts of problems. I think the large report will be attached to our report, and we're recommending that the Secretary of the Interior support the ideas set out in that Grant Thornton report. And of course, the government has an obligation to consult with the Indian tribes about this whole thing, and so that's what we expect will happen when this report hits the Secretary's desk on December 10th is when we're going to finally hand it over. We've also made a number of recommendations related to how litigation is handled. Mary's written a lot about Professor Wood, I should say, has written a lot about how the government takes such a narrow view of what its trust responsibility is to stop environmental degradation to tribal natural resources, tribal water, and so on, by importing some narrow standards that are imposed when monetary liability is attached to the United States. There's some terrible law out on the monetary liability, but the Justice Department has imported on its own that horrible law into the law of seeking prospective relief, injunctions against people who are harming Indian resources. And so the government won't bring these cases. Or it fights tribes when the tribes want to go after the Bureau of Reclamation or others who have caused harm to tribal resources by permitting waste to be deposited on lands that then leaches into the ground and harms tribal natural resources. So another part of the report recommends that Congress wipe out the government's defenses in these cases in both situations, so that the same standards that would apply to a private trustee in terms of monetary liability would also apply in the Indian context and for prospective injunctive relief. And Congress has the authority to do it, and I don't know if they will, but it's going to be our recommendation that that be the case, so that we don't have a situation where the United States is asked to file a suit on behalf of the tribe and comes back and says, well, only if you will waive your members' claims against us, or only if you will waive any other future claims against us that you have in related but not the same context, which happens frequently out of the Justice Department. So that part of the report, I think, I'm probably going to lose a few friends at the Justice Department over that, but it's something that we think should be changed. We heard a lot of complaints about it, and it's substantiated. And that was the good thing about taking our commission meetings out to Indian country was, we heard directly from people about, what these problems are and how they're caused, and what the government's response has been. So we have good documentation. We've also got issues of conflicts of interest. When the U.S. has representing the Bureau of Reclamation, let's say that Klamath project, and the tribe wants water for in-stream flows and the farmers want water for irrigation, a lot of this is not reinventing the wheel, but going back to the Policy Review Commission, which recommended that the tribes have an independent counsel to bring those sorts of claims. If the government has to pay for them, they've got an obligation to protect tribal assets. If they can't do it in the Justice Department because they have a conflict, then the tribe should be able to have Howie Arnett paid by the United States to bring the action in the name of the United States and on behalf of the tribe. And so it harkens back to a time in the 70s again when the United States would file split briefs in cases. And so the Justice Department would be A great example is a case involving the IRS was trying to tax an individual Indian's proceeds from some trust assets. And the Interior Department took the position that it was not taxable because it's held in trust by the United States, and the IRS didn't have a specific statute that allowed them to tax his property, and that was directly derived from these natural resources. And Reed Chambers, who was the associate solicitor at the time, got the Attorney General's office to agree to allow him to file a separate section of the brief on behalf of the Department of the Interior, reflecting the Indians' view. So you have this brief, and you read on for 30 pages by the Justice Department and the IRS about how they can tax it. And then you get to this income, and then you get to the last 10 pages, and it says that they can't. Signed Reed Chambers, and it was I can't remember. I think it was a Third Circuit case, but the judge said, "Well, the government can't even make up its mind about whether this is taxable, so she wins." And that was carried on for about 5 or 6 years. There were only 5 cases. The tribal position won in every one. And so we're wanting to resurrect that in some other form to stop this oppression that tribes face from agencies that have their own independent litigating authority, like the NLRB, for example. They've got all these labor law cases where the NLRB is taking positions that Interior Solicitor's Office doesn't agree with. But the NLRB is quite powerful, and so they're going after the tribes, and the tribes are losing some of these cases. So this is an idea that is going to be featured in our report. We've got a special section on Alaska that deals with the fact that, and I'll bring us back to 1970. So termination is rejected, self-determination becomes a policy. The Alaska Native Claims Settlement Act is passed, a modern-day treaty substitute terminating or extinguishing Aboriginal title in 1971. You tell me, is it termination or self-determination? The land does not go to the tribes. It goes to corporations that must be established under state law. The land to be held by these corporations and freely alienable, unlike trust land that's protected by the Trade and Intercourse Act of 1790. On the other hand, tribes can manage it without BIA interference. They're on their own. Not the tribes, the corporations can manage it. The tribes are just left as shells of governments but continue to exist. And so we bring the Venati case to the Supreme Court in 1998, and the Supreme Court says that ANCSA wiped out all Indian country in Alaska on 45 million acres that were transferred through that vehicle. That sounds like termination to me. The Department of the Interior had taken a position that it could not take land in trust in Alaska for tribes that do. Many of these corporations transferred their land back to the tribal governments because they didn't want to have a corporation. And those tribes want the department to take that land in trust so that they have governmental jurisdiction over it, and so it's protected from involuntary loss through taxes or alienation. And the NARF, again, the person who took my spot, Heather Kendall up in Anchorage, sued the United States, won the case, and in the district court, the United States decided not to appeal. That's a good thing. And so now they've got the authority to take land in trust. Of course, the state of Alaska has intervened and is appealing the case to the Ninth Circuit, or the D.C. Circuit, but it's a good victory, and Kevin Washburn told me he wants to take land in trust in Alaska as part of this administration. So I'm pleased about that. On the other hand, ANCSA, again, a termination aspect of it, wiped out Aboriginal hunting and fishing rights and didn't replace them with anything that's germane to the Native community. And so the statewide organizations of tribes and even the corporations are asking Congress to restore their Aboriginal hunting and fishing rights and protect them through a statute that would be similar to the protections that tribes have on reservation and off reservation, at least for purposes of hunting, fishing, game, for subsistence purposes. It's a food security issue in Alaska. And so those, Congress actually had a hearing on that. The United States just showed up to watch, but at least they were there. And one of our recommendations is going to be that the Congress codify the ACUCHEC, the land into trust win with the statutes so that you can wipe out any possibility of a loss on appeal. And then secondly, that these Aboriginal hunting and fishing rights be restored in a fashion acceptable to the Alaska Native community. So we've got some pretty far-reaching, small things like fix the website, to restructuring the entire, way Indian affairs are managed, and then restoring Aboriginal hunting and fishing rights. So it's been a really fascinating project to work on, and I hope that some of these things will get done, if not now, sometime far into the future. Now, not too far into the future. Now, I want to wrap up here by talking a little. I have these books here, and there's a huge stack of books. I want to thank you for getting them down here, Heather, Emily, and they're all the Cohen Handbook. So here's the 1941 original Cohen Handbook, written by Felix Cohen, but also a lot by his wife, right, Rennard, who didn't get the credit. And then we've got the Cohen Handbook that I learned Indian law from, which Rennard was the editor-in-chief, the 1982 edition. A 2005 edition that Rennard was on with me and several others in terms of the board of editors, and then a 2012 edition which has got Rennard's spirit all over it. And what I wanted to read, I was going through my files, and my predecessor at the University of Washington was a guy named Ralph Johnson, one of the first people to teach Indian law, and he passed away in 1998, but I have his papers, and I went and included in those papers are interesting memos from Rennard and all the people that were working on the Cohen Handbook, and Charles Wilkinson, who was, I think Charles was here at the time. He had moved, memos indicating he was moving from here to Boulder. But there's a whole set of correspondence where they were trying to get this thing done in 1981, and with multiple authors, it's you're always behind. But they had cut off case analysis in March of 1981, and now here we are up to December and into January, and the book hadn't been published yet. But still, some vocal and persuasive members of the editorial board were trying to get Rennard to call it the 1981 edition. It says 1982 edition here, and they wanted to say, well, it's 1981. And so Rennard, this is to the Cohen board, January 18th, 1982, 1981 versus 1982 edition. I think we have reached the newspeak question in the Cohen project. I fear there were times when we would have a 1984 edition, but we seem now to have an Orwellian 1984 problem. I think it is intellectually indefensible to label an edition published in 1982 as the 1981 edition. I understand the reason, which is to highlight the fact that the book ends with March 31st, 1981 in terms of case analysis. We say this in the front matter. My opinion, which was not asked, is that when we went into 1982, we went into a 1982 edition. The copyright will say 1982, and to label the edition anything else will be very confusing. Then the book finally comes out, and here's my favorite. Final memorandum, it says, to Cohen Board, from Editor-in-Chief, publication, April 7th, 1982. Cohen's Handbook, 3rd edition, published April 6th, 1982, RIP. This is the way the world ends. This is the way the world ends. This is the way the world ends. Not with a bang, but with a whimper. And I'm done too. Thank you.